Welcome back to the Deep Dive. Today, we're tackling what is arguably the most subjective and controversial area of tort law, the calculation of damages.
Right.
We're moving past the question of who is liable, which is often, a pretty clear legal determination, and we're diving into the really messy work of attaching a dollar amount to pain, suffering, and lost futures.
It's exactly where legal theory slams into financial reality. Liability, that relies on established standards of care.
Sure.
But compensation is so discretionary. It's all about expert predictions and, honestly, the very subjective judgments of a jury. We're trying to make a person financially whole, which means we have to value the invaluable.
Valuing the invaluable. It's a great way to put it. And to frame our mission for you, our sources define three main types of damages. You've got nominal, which is mostly symbolic.
Like a dollar.
Exactly. Then compensatory, which aims to cover all the losses, both financial and emotional. And finally, punitive, which is purely about punishment and deterrence.
And for this deep dive, we're really going to focus on the three big policy battlegrounds within that framework.
Yeah.
First, we'll get into the tricky definition of compensatory damages for intangible injuries, specifically that controversial consciousness requirement. Then we'll jump into punitive damages and look at the huge constitutional limits that the Supreme Court has set up.
Right.
And third, we'll tackle the complex world of allocating loss when you have multiple tortfeasors, which brings up things like joint and several liability reforms.
Perfect. So let's start with compensatory damages for personal injury. We all know this covers things you can count, like medical bills. But let's talk about lost income. What's the fundamental legal difference between compensating for lost wages versus impaired earning capacity?
That's a great question. Lost wages is pretty straightforward. It's a simple calculation of the actual income you missed because you couldn't work.
Past tense.
Exactly. But impaired earning capacity, that's a much broader concept. It measures the victim's lost potential to earn income because of the injury. And the key legal nugget here is that it doesn't depend on proof that you had already used that capacity or even that you definitely would have.
So if I'm injured at 18, right before I start college, the defense can't just say, well, you never worked a real job, so you lost zero income. I can still claim compensation for the future I was robbed of.
Precisely. You're being compensated for the lost opportunity to use your time, your skills, your potential, however you would have chosen.
But you still have to prove that potential, right?
Oh, absolutely. The plaintiff has to prove, using evidence like aptitude tests, grades, personal history, that the capacity was actually there before the injury. For instance, the source material notes, if a victim failed to get into a 4-year university before the accident, it would be pretty hard to then claim the impaired capacity to become, say, a high-earning lawyer.
That makes sense. It sets a tangible standard for what's otherwise a guess about the future. Now, let's move into the really tough area. Non-pecuniary losses. The intangible costs.
The hard stuff.
Yeah, we're talking about pain and suffering. And that can include mental distress, disfigurement, the emotional toll of a shortened life. But critically, how do we value the loss of enjoyment of life?
So loss of enjoyment of life, sometimes it's called hedonic damages. It's meant to measure the loss of the ability to pursue pleasurable activities, sports, hobbies, just living. But the major legal hurdle, the policy debate, is whether the plaintiff has to be aware of that loss to get compensation for it.
It just seems impossible to measure. If I can't play guitar anymore because of an injury, how does a jury turn my sadness into a dollar amount? And what if I'm not even aware that I'm sad?
The general rule is actually built around that exact subjective experience. Compensation for pain and suffering, and this includes loss of enjoyment. It's highly dependent on proof that the victim was conscious of their injuries and, the negative implications.
So no consciousness, no recovery.
Generally, that's the rule. If the victim is unconscious, they typically can't recover for that specific loss.
And this brings us right to a key case that really drew a hard line in the sand. McDougald v. Garber. Let's break this one down. First, what are the legally dispositive facts?
Okay, so in McDougald, the plaintiff suffered these just devastating injuries from medical negligence.
Right.
And it left her permanently comatose, totally unconscious. The lawsuit sought significant compensation for non-pecuniary losses, specifically for her loss of enjoyment of life, even though she had zero awareness of that loss.
And what was the core legal issue for the court?
The precise legal issue was this. Can a permanently unconscious plaintiff recover compensatory damages for the loss of enjoyment of life when that plaintiff has no conscious awareness of the loss at all?
So what rule of law did the New York Court of Appeals apply here? Can you state the full rule and then break it down into its testable elements for us?
Of course. The majority rule holds that these non-pecuniary damages are only compensable when they relate to the conscious perception of the loss. So what the court did was it fused loss of enjoyment back into the bigger category of pain and suffering.
Okay, so it's not a separate thing.
Not according to this court. And that rule has two key elements. First, you need proof of an actual physical injury. And second, and this is the big one, you need consciousness of the non-pecuniary loss or its negative implications.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the proof of actual physical injury?
That one was easy. The first element was clearly met. The plaintiff was rendered permanently comatose due to the defendant's negligence. That's a massive physical injury.
Understood. Now what about the crucial second element, the consciousness of the non-pecuniary loss?
Right. This is where the court did a really deep, almost philosophical analysis. It reasoned that pain and suffering, by their very definition, require some level of cognitive awareness to be experienced.
You have to feel it to suffer from it.
You have to feel it. Since the plaintiff was permanently unconscious, she couldn't experience the distress, the anxiety, the sorrow that's at the heart of suffering. So the court concluded that an unconscious person fails this second element. They just can't experience the subjective harm needed for this kind of compensation.
But hold on, what about the dissent? Didn't they argue that losing the ability to enjoy life is an objective loss, whether you're aware of it or not?
They absolutely did. The dissent's point was that loss of enjoyment is an objective loss of a fundamental human right, the right to live fully. And the money should represent that objective loss of life's value, regardless of the victim's subjective awareness. But the majority rejected that.
Wait.
They were afraid of creating a purely economic, objective valuation of life itself, completely separate from suffering. They worried about these huge arbitrary awards where a jury would be trying to put a price tag on a life without cognitive function, which is a very different thing than compensate her for emotional distress.
That is a stark line to draw. It really places financial value directly on cognitive function. That's a serious policy choice.
Right.
Now, let's move away from awareness for a second and talk about a victim's responsibility to limit losses. I want a visceral hypothetical here to explain the rule of mitigation or the doctrine of avoidable consequences.
Let's use your example. A defendant's negligence causes a simple cut, a laceration. But the plaintiff unreasonably refuses to go to the hospital for stitches because they have, say, a minor phobia of needles.
Okay.
The cut gets severely infected, and the limb has to be amputated.
So who pays for the amputation?
The defendant would not be liable for that incremental loss, the amputation. The rule of mitigation requires the injured person to act reasonably to limit their damages.
So by refusing basic medical care.
By unreasonably refusing readily available necessary medical care, the plaintiff failed to mitigate. The defendant is only liable for the damages from the simple cut, not for the avoidable consequences of the infection and the amputation. It's about making sure the defendant only pays for the damage they actually caused.
Excellent. That's very clear. Okay, let's shift gears. We've talked about compensating the victim. Now let's talk about punishing the wrongdoer. This brings us to punitive damages. What's the fundamental goal of these damages, and what's the legal standard for imposing them?
Punitive damages really have two goals: retribution for outrageous conduct and deterrence of similar behavior in the future.
Right.
They're highly discretionary and require proof that the tort was committed with malice, which can mean ill will or hatred, but more commonly, it just means a reckless disregard for the victim's rights or safety. And a key factor is the defendant's wealth, because a punishment has to actually sting to be a deterrent.
And this potential for huge awards tied to a defendant's wealth.
Yeah.
That's exactly what brought in the Constitution, right? The Due Process Clause of the 14th Amendment.
Yes.
Which takes us to the landmark case, BMW of North Dakota, Inco v. Gore. Let's set the scene. The plaintiff bought a new BMW that had some undisclosed damage from before delivery. It lowered the car's value by $4,000. The jury awarded $4 million in punitive damages.
Yeah, that ratio alone was going to set off some alarm bells.
Let's analyze BMW v. Gore. First, what were the legally dispositive facts?
The key facts were that low compensatory damage number, $4,000 for purely economic harm. The car's repair history wasn't disclosed, versus that astronomical punitive award of $4 million.
And the core legal issue that went all the way to the Supreme Court.
The precise constitutional issue was whether a punitive damage award that is so grossly excessive, specifically that $4 million award, violates the defendant's substantive due process rights under the 14th Amendment.
What rule of law did the Supreme Court apply to test this? Please state the full black-letter rule and break it down into its three testable elements, the three Gore guideposts.
Okay, so the Supreme Court said that punitive damages have to be reviewed for excessiveness using three constitutional guideposts. The award is excessive if it violates these. The elements are, 1, the degree of reprehensibility of the defendant's conduct; 2, the disparity or the ratio between the harm suffered and the punitive award; and 3, the difference between the punitive award and any civil penalties that are authorized in comparable cases.
Thank you. Now for the court's elemental analysis. How did the court apply that first element, the degree of reprehensibility?
The court found the reprehensibility here to be pretty low. I mean, yes, the non-disclosure was intentional fraud, but the injury was purely economic. It was just property damage.
No one was hurt.
Right. The court looks for things like violence, or if the conduct endangered health or safety, or targeted a financially vulnerable victim. None of that was here. So this element really didn't support a massive award.
Understood. Now, what about the crucial second element, the ratio between punitive and compensatory damages? This is where the numbers just get wild.
Absolutely. The ratio was 1,000 to 1, 4 million to 4,000. The Supreme Court said that due process requires fair notice of the penalty for your actions, and a disparity that huge is just unconstitutional. And in later cases, like State Farm v. Campbell, the court basically said that ratios exceeding single digits, think 4 to 1, are probably the constitutional ceiling, unless the compensatory damages are tiny or the conduct was truly extreme. 1,000 to 1 ratio is just indefensible.
But why single digits? Where does that come from? Is it just an arbitrary number?
It's not totally arbitrary. It's rooted in historical ideas of proportionality, the idea that punishments shouldn't exceed reasonable standards. The general consensus is that a 4 to 1 ratio usually covers the need for deterrence without becoming constitutionally arbitrary. It sends a message that the penalty won't just be double or triple the harm.
Okay. And finally, how did the court analyze the third element, comparable civil penalties?
The court looked at similar civil or criminal fines for that kind of non-disclosure in the state, and they were minimal. They ranged from $50 to maybe $10,000 max.
A huge difference.
A $4 million penalty bore no rational relationship to what the legislature decided was the appropriate penalty for that same conduct.
And after analyzing all three elements, what was the court's final conclusion?
The Supreme Court concluded that the $4 million punitive damage award was constitutionally excessive and violated BMW's due process rights. And this case is now the primary check on out-of-control jury awards. It forces courts to maintain some kind of rough proportionality.
That framework provides some really essential limits. Now, let's pivot to a different kind of fairness. Allocating the laws when a plaintiff has multiple places to get recovery from. Let's start with the collateral source rule. If a plaintiff gets paid by their own health insurance for medical bills, can the defendant then argue, hey, we shouldn't have to pay those bills because they've already been covered?
Under the traditional common law collateral source rule, the answer is no. A plaintiff's recovery from the defendant is not affected by compensation they get from collateral sources, like their own health or disability insurance or even gifts. And evidence of those payments is generally kept out of the trial.
So the plaintiff can essentially get a double recovery. Why is that allowed?
Yes, the plaintiff can get what looks like a double recovery, and it's definitely controversial. But the policy reason is simple. The person who committed the tort shouldn't get a windfall from the victim's own prudence in buying insurance.
I see.
If a benefit has to go to one side or the other, it should go to the innocent victim, not the wrongdoer. Now, if the insurance company wants its money back, it can pursue that through subrogation. But we should note, a lot of state legislatures, especially in medical malpractice cases, have passed reforms that get rid of the collateral source rule to try and lower insurance costs.
That's a huge policy debate right there. Okay, Let's move to the ultimate allocation problem. Multiple defendants.
Yeah.
In modern comparative SALT systems, if 3 different people cause an injury, how is the liability divided up?
So liability is divided by the proportion of responsibility that each person bears. The jury figures that out. It's not just split equally by the number of defendants. So, the jury might find defendant A is 60% at fault, B is 30%, and C is 10%.
Now, let's add the insolvency problem, which is where it gets messy. Under the traditional rule of joint and several liability, what happens if defendant A, the 60% at fault party, is insolvent and can't pay? But defendant B, who's only 30% at fault, is solvent, Who pays A's share?
Under traditional joint and several liability, the solvent defendants, in this case defendant B and C, have to make the plaintiff whole. They have to pay the entire remaining amount, which includes the insolvent defendant's 60% share.
Wow.
Yeah. The rule is designed to maximize the chance the plaintiff gets fully compensated, but it leads to the famous deep pocket dilemma.
The dilemma being that a defendant who is only a little bit at fault, maybe 10%, could be forced to pay 100% of the damages just because they're the only one with money. The liability is completely out of proportion with their fault.
Exactly. And that's the core policy debate. Do you prioritize making the innocent plaintiff whole, even if it means hammering a minor defendant? Or do you prioritize fairness among the defendants, which means the plaintiff might have to absorb the loss from the insolvent party?
And that's why states have reformed this.
It's precisely why many states have adopted reforms limiting joint and several liability. Like maybe it only applies if a defendant is more than 50% at fault, for example.
That's a critical distinction. Okay, one last thing on this. How does a pretrial settlement with one person affect the liability of the others who didn't settle?
This is huge, and jurisdictions usually take one of two main approaches, and each one allocates the risk of a bad settlement differently.
Let's start with the approach that encourages people to settle.
Okay, that's the deduction from total damages approach. Let's say defendant A settles for $1,000, and the final judgment against everyone is $10,000. The court just subtracts the $1,000 payment from the total.
So the other defendants pay $9,000.
Right. The remaining defendants, like B, pay the $9,000 balance. The risk of A settling for too little falls on the defendants who didn't settle, which gives them a big incentive to settle early, too.
And the second approach, the one that protects the defendant who goes to trial.
That's the deduction by percentage of fault approach. Under this rule, the settling defendant's percentage of fault gets deducted from the judgment no matter how much money they actually paid.
Oh, that's different.
Very different. So if A was 60% at fault and settled for only $1,000 and the judgment is $10,000, the plaintiff only gets B's 40% share from B, which is $4,000. In that scenario, the plaintiff bears the risk of having accepted a bad settlement from A.
We've covered a ton of ground here, from valuing careers to constitutional ratios and the deep pocket dilemma. This is a massive amount of material. Can you synthesize all of this for us into an actionable, step-by-step diagnostic checklist for the learner to use when they see a complex damages question?
Absolutely. Think of this as your 7-step checklist for spotting damages issues.
What's step 1?
Step 1, identify damage type. Figure out if the claim is for nominal, compensatory, either pecuniary or non-pecuniary or punitive damages. Start there.
Step 2.
Step 2, calculate pecuniary loss. This includes medical expenses and, really importantly, assessing impaired earning capacity. And always remember that any future losses have to be reduced to present value.
Step 3.
Step 3, calculate non-pecuniary loss, pain and suffering. Here you have to apply the consciousness requirement from McDougald v. Garber. If the plaintiff is unaware of the loss, those damages are typically out.
Step 4.
Step 4, mitigation check. Did the plaintiff act reasonably to limit their losses? If not, you deduct the avoidable portion of the loss from what the defendant has to pay.
Step 5.
Step 5, collateral source check. Apply the common law rule. You ignore payments the plaintiff got from third-party sources like insurance, unless there's a specific statute in that jurisdiction that changes the rule.
Step 6.
Step 6, punitive damages check. Is there proof of malice or reckless disregard? If the answer is yes, then you have to apply the 3 Gore guideposts, reprehensibility, ratio, and comparable penalties to make sure the award is constitutional. And finally, step 7, allocation check. If you have multiple defendants, you have to check that jurisdiction's rule on joint and several liability for insolvent parties. And then you have to figure out how any pretrial settlements affect the remaining defendants. Is it a straight dollar deduction, or is it a percentage of fault deduction?
That structure is the perfect tool for navigating this. Today, we've really seen the law struggle with translating human loss, a life, a potential and emotional toll, into a standardized financial number.
The arbitrary nature of that final number is, I think, unavoidable. The system has to balance the victim's right to be made whole against the need for penalties that are fair and predictable for the defendant.
Absolutely. And as we wrap up, I think the greatest tension running through all of these rules, from the consciousness requirement in McDougald to the ratio in Gore, is this fundamental philosophical clash. Is tort law primarily a compensation system designed just to make the injured whole? Or is it a quasi-criminal system designed to punish and deter wrongdoing?
That is the perennial question, isn't it? And punitive damages are the clearest example of that conflict. They give the victim a windfall, and they turn the civil system into a kind of private prosecution against reckless actors. And until we, as a society, fully resolve whether compensating victims or punishing wrongdoers is the number one goal, we're going to keep seeing these debates over damage caps and what fair compensation really means.
Food for thought indeed. Thank you for guiding us through this critical area of the law.